and welcome back to AASA, the School Superintendent Association's Public Education Policy Podcast, or PEP Talk for short. I am Kat Sturdevant, the AASA Advocacy and Governance Coordinator, and your host for each episode. We're keeping up our regulatory momentum and diving into a deep and thorough discussion about the new 2024 Title IX regulations and everything superintendents need to know, from the changes in the rules, effective implementation, and what exactly is going on with all this litigation in states. So without further ado, let's get to the episode. All right, let's get started. Holly, do you want to introduce yourself first?
Hi, my name is Holly McIntush, and I am a partner at the law firm Thompson and Horton. We're a Texas-based law firm, but we do a lot of civil rights work and Title IX work, and we've been excited to be partnering with you guys, both AASA and Jackie, on some of this work. I do litigation, but my favorite part of my job is not litigation. It's advising school districts on how to avoid litigation and more importantly, how to do it right. Not just avoid litigation, but really get this right, because these are such important issues. Civil rights issues generally, harassment, bullying, it all gets mixed up into one. And I really want to help schools do their Title IX job right. And so I'm really excited to be here and help provide a little bit of insight on some of the questions that school districts have about the rules.
We're really excited to have you. And Jackie?
Yes, hi. Thanks so much for having me. It's great to be here. I'm Jackie Gharapour Wernz. I am a little bit of a different space. I'm more of a consultant, and I'm an expert witness on civil rights and Title IX issues. I am a lawyer, but I really just focus on civil rights. And another thing that makes me somewhat unique is that my scope of my practice is much more on a national level. So I live in Texas, my job is in Idaho, and my clients are all over the country. So I am, I'm really not, your typical law firm that is going to do a little bit of everything, but more focused on just constitutional and civil rights issues that schools are facing. And I've been doing this for, I guess maybe about 17 years at this point. And I think people really know me the most for my passion when it comes to Title IX issues, and just really kind of thinking through how to improve schools' responses on the outset so that they don't have to go out and hire a law firm to defend them after the fact. And yeah, just really excited to be here. Thank you so much for having me.
So I'll start with a sort of 1,000-foot view question of the regulations. Jackie, do you want to give us an overview of what the Title IX regulations cover?
Yeah, so I guess, there's two sort of 1,000-foot or 10,000-foot views. One is, what are the Title IX regs just generally? So Title IX is a federal law that is actually quite short, and it prohibits discrimination based on sex in educational programs and activities that are receiving federal funding. So that's all K-12 school districts pretty much. And so that law is, again, it's very short, doesn't really say a whole lot. But there are, much like how a school district has its board policies, and then it also has its administrative regulations or administrative procedures, the federal government has that same kind of setup. So Title IX is the statute, is like the board policy. And then there are regulations that are issued by, in this case, the Department of Education. And the Department of Education issues regulations in order to give a little bit more detail on what expectations are for compliance with the law. And these aren't new. We've had regulations for a long time, but for a while they didn't address sexual harassment at all. And then in 2020, under the Donald Trump presidency, we, for the first time, got regulations that address sexual harassment and that really set forth very specific procedures and requirements that needed to be used anytime a school district was facing a complaint of sexual harassment. So we've been living under those rules for 4 years at this point, but with the change of presidential administration to Joe Biden's administration, we got new regulations, and those regulations actually do continue a lot of the same practices and procedures as the 2020 regulations, but they do pare back on the procedures quite a bit, especially for K-12 schools. So that's kind of the positive of what we're dealing with right now, is that if these regulations go into effect on August 1st, which is when they're supposed to, we'll be getting a little bit of a break in the K-12 space on what procedures we're required to use. And that's important because it's going to impact how long these processes take. It's going to impact how quickly schools can therefore respond and help address conduct in their environment that needs to be addressed. There are some very controversial parts of the proposed, or I guess now final rules. They feel a little proposed because we're going to talk about lawsuits, I think. So it feels like a little bit is still hanging in the balance. But these rules, for example, will expand the definition of sex-based harassment and sex-based misconduct to include, for the first time, explicitly sexual orientation and gender identity. And that is what a lot of the arguments are about these rules, is whether or not they should be broadened to include gender identity, sexual orientation, and some of the more controversial elements of how those things come into play. But I do, always like to point out to people that that is a tiny sliver of what these rules do. And you asked me for a, high level description of it. So I'm going to stop there because there is so much more in these rules that I know we're going to dig into, but that would be my 1,000 foot overview.
Perfect. And of course, with both of you, actually, we've created a bunch of resources and stuff. So if they didn't quite catch all of that, they're more than welcome to read the resources that will be tagged in the show notes. So next question is for Holly. I want to ask, what are the major grievance requirements that K-12 schools must follow now, and how are they different than what they had to do before?
I'm going to start with the second part of that question and tag on to what Jackie was saying. The big change here is that the actual procedure, the rigorous steps that you have to follow are significantly fewer. And that is going to be good news for our K-12 clients once these rules go into effect, whenever that is. But the key thing that the real key issue here is that you need to be responding to all forms of sex discrimination in a manner that helps you end discrimination in your programs and activities and prevent its reoccurrence, which is a huge job, right? But in terms of how you go about doing that, the key thing is, first of all, when we need to make sure that all employees know that they have to report sex-based discrimination to their Title IX coordinator. So the Title IX coordinator can make sure all the other pieces of this process go into effect. And the coordinator is going to step in and support the student who is the subject of the behavior and begin, if they want it, or if the school district feels it's necessary to prevent discrimination from happening and reoccurring in its program, then it needs to step in with the grievance procedure. That grievance procedure, though, like I said, and like Jackie said, is a lot more simple than it used to be. You can have one person serve as both the coordinator, the investigator, and the decision maker, or you can separate those roles out however you want to separate them out. What we recommend, if you have enough people to do it, is to have a coordinator separate from the investigator and decision maker. But in the end, all of that is not what's important here. What is really important is that you follow the requirements of the rules, that you have to provide notice like you did before, but there are a lot of deadlines that were built into the old rules that are not there before, that are not there anymore. We don't have to, there are no set review periods, for example, to review the evidence and then wait 10 days and then provide an investigation report that doesn't make any findings of fact and then wait 10 days and then allow people to question each other back and forth through written question and answer process and then make a determination. Instead, it's going to look a lot more like what most schools already do for their other conduct. suspect investigations. And so it's going to be, you can have one person who comes in, who investigates, who makes the findings and issues a written determination. There doesn't have to be a separate investigation report. And that written determination can be a lot more simple than it used to be. So I really think this is going to be good news for our K-12 schools. They're going to be doing what they do best, which is supporting kids and responding to misbehavior, but doing it in a manner that looks a lot more like their other processes.
Yeah, the only thing I would say in addition to that is that, when I think about what these rules require that they didn't require before, I think one of the really big issues is that previously we were dealing with a rule in the 2020 rule that dealt only with sexual harassment. And so what that meant was that if we received a complaint of other types of sex discrimination, like discrimination in equity between girls and boys sports teams, or if someone says, hey, I think I'm being disciplined more harshly than someone based on my sex, or even retaliation. If someone says, I reported sex-based misconduct and now I'm being retaliated against by my teacher or by my peers, all of those things were left open to the school district's discretion as to how to handle them. And if they were listening to people like me, they were not using their Title IX process to address them because it was a bulky process and it wasn't required. Now, these new regulations require that you use them for all complaints of sex discrimination. And so that's going to include not just sex-based harassment, but also all other types of different treatment, different impacts that you might have based on a neutral rule. Failure to accommodate someone based on their pregnancy status, athletics equity, retaliation, all of those things are now being pulled under this rule. And so this is a really great opportunity, I think, for school districts to get back to some basics of, thinking about how they respond generally to civil rights complaints. Because the thing is that, as Holly mentioned, because this now process is being pared down and starting to look more like something that you would use in other types of civil rights complaints in a K-12 school district, this is a really good chance to say, hey, maybe we need to take a look at how we address all types of harassment, discrimination, retaliation based on protected statuses, and think about trying to come up with something more coherent and consistent for addressing all of those types of behaviors. Because even though I know we're here to talk about Title IX today, if you're paying attention to the news, the U.S. Department of Education just issued notice that it has slammed a number of educational institutions across the country on how they're handling complaints related to the war in Israel and Gaza. And that isn't Title IX, people. That is Title VI. That is race, color, national origin discrimination. And so because they have increased the umbrella of Title IX while also narrowing the types of procedural requirements that they're putting in place, this is a great time to start thinking more consistently and holistically about how your school district responds to all types of civil rights complaints.
Absolutely. I completely agree with that. And I also think that it's a wonderful idea for when you go to trainings and you learn tips and tricks for how to deal with and respond to sex discrimination, and especially how to investigate and how to write your rationale to explain your determination. Those are all things that you should be doing in all of your investigations, and all of those tips and tricks that you would learn from Jackie and her trainings, or me and my trainings, are things that you can apply in your other investigations.
I really appreciate that clarification about that and the urge to sort of look at all policies. I want to dive into the content of these policies, starting with there's been a lot of focus on the Title IX regs that has been what these regs mean for students who identify as LGBTQI+. Some say that the districts now allow any child to use any restroom or locker room they want, carte blanche. Others say that there's implications for athletics. I'll start with Jackie, and then Holly, if you'd like to jump in afterward. Can you break down what these regulations do in the context of LGBTQI discrimination and harassment, and what has really changed for districts?
This is such a complicated issue, and honestly, we could sit and talk about this for a full podcast or maybe 5. So I'll try to hit some of the high points on this, but the main thing to keep in mind is that these regulations would, for the first time, codify that within the definition of sex for which discrimination is prohibited under Title IX, within that definition of sex would include sexual orientation and gender identity. Now, that is not such a change because the U.S. Department of Education's Office for Civil Rights has actually, for decades, interpreted Title IX to prohibit discrimination based on failure to comply with gender-based norms. So if a person is, not meeting what the expectations are for a boy or a girl traditionally, like, you've heard people making comments like a boy throws like a girl, or a girl is a tomboy and needs to act more feminine. Those types of things have been protected for, as I said, decades at this point by Title IX. And so what this change would do would be to say that your status as a person who has a particular sexual orientation or gender identity would also be protected. And the thing that I think helps clarify this distinction for people is I described that when I worked at the U.S. Department of Education at the Office of Civil Rights, when we would receive a complaint that said, I've been being made fun of at school for being gay. People are calling me slurs that are related to being gay. They're calling me, they're calling me the F word that is used for someone, really horrible slur used for someone who is gay, or they are calling me the D word that's sometimes used for lesbians. Hopefully you guys know what I'm talking about. I don't say these words, but if that was all that was in a complaint, we would dismiss it from OCR. We would not investigate it because that relates purely to a person's status, their sexual orientation status. However, if we received a complaint where someone said, I'm being made fun of because I'm gay, and what they're saying is, your voice sounds too feminine, your dress is too feminine, you don't act like what we would expect a person of your sex to act, OCR would have investigated that again for decades. So that has been something that has been covered by Title IX. What this rule would do would specifically say your status as a person who is gay or bisexual, a person who is transgender or a non-binary, that status is protected. The really big change here, though, is the creation of a test that says that you can't separate people based on their sex within a school program if it causes more than a de minimis harm to that person who's being separated. And what they say is they don't give us any real factors or things to consider for that test, but they say, hey, by the way, anytime you separate someone based on sex and you exclude a person because of their gender identity, you are creating more than a de minimis harm, unless it's in athletics programs. So really, even though they create this very broad reaching de minimis harm test, it can really be boiled down to a test that says you aren't allowed to keep a person out of a sex-based distinction that you use in your school program based on their gender identity, based on being transgender, non-binary, those types of descriptions. And so that is where there is a really big argument brewing in the courts and in the court of public opinion about these rules. And you asked about bathrooms and locker rooms. And my short answer to you is that the rules as written would appear to require that if you separate bathrooms and locker rooms based on sex, that you allow a person to use the bathroom or locker room that matches their gender identity. There's not an exception in the rule like there is for athletics for bathrooms and locker rooms. So if the rule went into effect as written, that would be the new standard, is that you are required to allow someone to use a bathroom or locker room that matches their gender identity. Also, some really tricky ones to think about: pronouns. Is the fact that we call some students he and some students she, is that a separation, a distinction based on sex? I think it is. Does this rule now mean that you cannot exclude a person from those categorizations based on their gender identity? I think there's a good argument that that is what this rule says. The only exceptions in the rule are for if you are looking at athletics programs. The Department of Education issued a proposed rule not too long ago that they were pushing through the regulatory process that would address and create a new test for athletics teams. That rule was not finalized. It does not appear to be that it's going to be finalized during this presidential term. And so there is an exception in the rule that says you are not required to allow individuals to participate on an athletics team that matches their gender identity under Title IX.
This is also substantive and important for us to cover, so I really appreciate the deep dive. Holly, do you have anything to add?
Yeah, one thing, which is that in addition to separating out athletics, there is a separation for for certain classes that are covered under the regulations that are an exception. And part of them feel like they're athletics, right? Because it's basically talking about PE classes, and it talks about how those are accepted out because it accepts out anything that are covered under certain parts of the regulations. And one of them are PE classes where it's based on physical strength or skill. But then again, it has to be because you've met that physical skill. You should be able to participate no matter your sex or whether or not you're transgender. But if it's a class that is based on physical contact, so wrestling, for example, then that would be separated out. And there's also an exception for choirs, but again, that's kind of like the exception for skill level. It basically says if you have a choir class where you require a certain vocal range or quality, then even if that results in more males or more females in your program, you can still do it. So if you have a transgender student who meets the vocal range, a transgender female who meets the vocal range for the girls' choir class, you're going to have to let them participate, right? And so in some ways it's listed as an exception, but it's only an exception if it's truly based on the vocal range, the vocal quality, or in the PE class section that's not a contact sport. It would need to be something that is really truly based on, can they reach this skill level? If they can't, then they can't participate, and it's not discrimination, even if they're a transgender student, right? But if they can, then you've got to let them participate.
Talk to me about the new protections for pregnant and parenting students and employees, and why districts need to be much more cognizant of those now in the new regs, Holly.
Well, honestly, a lot of the protections were already there under other laws that required protections for pregnant and parenting students and employees. However, the key things are, one of the key things is what Jackie mentioned earlier, that any complaints of discrimination or including failure to provide reasonable accommodations all have to go through this new grievance process. So that is something that wasn't swept into the grievance process before and is now. But the key is you can't discriminate against students who are pregnant or have a pregnancy-related condition. Pregnancy-related conditions includes miscarriage, termination of pregnancy, and all sorts of other things that we need to be paying attention to, things that are related to your pregnancy or your medical condition. And so if a student comes to you and says, I'm pregnant, that means now employees have to not report that, but they do have to tell the student that the Title IX coordinator can help them and how they can help them. And that is a new key change that was not there before. So all of your employees need to be aware of the types of accommodations that the Title IX coordinator can provide, but more importantly, that the Title IX coordinator can provide them, and that they need to direct students or parent who are pregnant, or parents who report to them that a student is pregnant, to the Title IX coordinator so they can ask for help. And then the Title IX coordinator or their designee can work together with the student in an interactive process, similar to what your school district's HR coordinators and ADA and 504 coordinators are going to be familiar with, an interactive process of working together to come up with reasonable accommodations. And the rules provide a list of things that are considered reasonable, such as a different desk space, or ability to turn in assignments late if they missed class or were unable to work on it because of a pregnancy related condition. So that is really important. And then you also have to provide lactation space, a private space that isn't a bathroom. That has to be available for students and employees who are lactating, and they need to have time and be given breaks to use that space, and that the amount of time that they're given has to include everything that would be related to that, right? They have to be able to walk to the space, get there, pump or breastfeed, store the milk if needed, and then return to their work or their classroom. And so one of the things that school districts are going to need to be thinking about is, where is that space going to be, and how are they going to make sure that it is a private, secure space for such a personal practice?
Yeah, I think, so in my day job, full-time, I run the civil rights department for a flagship state university. And one of the things that I think is the most interesting about these new regulations, as we think through how we have to implement them with respect to pregnancy, is with respect to just the recognitions that leave has to be granted as long as it is medically necessary, and what that looks like. Because sometimes an individual may, after having a baby or another pregnancy related condition, may need to be out for quite a while as a student. And so what is that going to look like when that person comes back? How are we going to balance our legitimate attendance requirements with requirements under the regulations to make sure that the student is able to return without any negative impact on their status? These are some of the really interesting questions that I think we're having to think through beyond just the logistical things that, like lactation space and things like that, desk space, things like that. So, the really interesting change to me here is that whereas previously we sort of treated pregnancy, we just had to treat it no worse than we treated other temporary conditions or disabilities. And because of that, we had a lot more flexibility on saying, well, we're not going to let anybody be absent for that long without this consequence. Or, we're going to treat pregnant people fairly, but we're not going to create some special rule for them. Now, these regulations really focus us much more on pregnancy as its own independent right, and particularly tied into what the physician says is the appropriate amount of leave for someone who is experiencing pregnancy or a related condition.
I'm going to shift a little bit to training requirements. How do the new regulations address the training requirements for Title IX coordinators, district administrators, and other K-12 staff in schools? I'll start with Jackie.
Yeah, well, hopefully they won't make too big of a change for K-12 schools, because hopefully you have been thoroughly training your Title IX team members. So Title IX coordinators, deputy coordinators, investigators, decision makers, appellate decision makers, and informal resolution facilitators. Hopefully you've been training those people over the last 4 years. You're in a good pattern. You know what resources you're using for that kind of training. You're just essentially going to shift that focus from the 2020 rules to the 2024 rules when that time comes. And I think we're going to talk about lawsuits in a moment, so I won't get into that yet, but I will say that, I have, again, in my day job of running a program and being responsible for training people, I've really had to rethink what my training is going to look like this summer because of some of the uncertainties about what rules are going to be in effect in my state. We are in one of the 10 states that is covered by a current injunction. And so we are not likely going to see the rules implemented on August 1st. You still need to do training. I have never met a Title IX team that didn't need annual training, but whether or not you're going to be training on the nuts and bolts of the 2024 rules, if you're in one of those states, my concern is that my team is going to forget those by the time they actually need them, and that they, on the other hand, are not going to receive training that is essential for using the 2020 rules if we are required to do so. So we're kind of trying to strike a balance. And I actually wrote a blog post on this on my Civil Rights Insights blog, which I'll share the link if you guys want to share it, about training and kind of how to think through those types of impacts. But with respect to the training of all employees, I also hope that this isn't going to be a big lift for you, because I hope that you've already been training all of your employees on their responsibilities under Title IX. Those responsibilities include being able to identify what is sex-based harassment and misconduct, and knowing who to report it to, specifically to your Title IX coordinator, and giving them examples of what those things look like. I've been doing training for schools on that for, the past 4 years and well before that, because it's always been best practice. It is going to be now required under the 2024 rules. So you don't have a choice anymore about doing what we've always known was the most reasonable thing for you. So you do need to make sure that you are offering some training for employees on that. One of the really interesting things about that is that, again, it's not like we're dealing with some brand new idea here that requires a big lift as far as creating what that training would look like. This is getting back to basics with your employees. The way I train on it is, if it involves sex or, frankly, race, color, national origin, disability, if it involves any of those things, report it up the chain. Because as an employee, as a rank and file employee, that is way above your pay grade to have to decide whether a civil rights process needs to be used to address that. And each school district already has non-discrimination coordinators in place for making those decisions. So really focusing on making sure that employees are trained on knowing what sex-based misconduct looks like and knowing that who they should report it to is really going to be, it's going to cover most of your bases on this. The one kind of tricky new element here is with respect to a new class of employee that's identified in the 2024 regulations, and that is confidential employees. Confidential employees are defined in the regulations for K-12. They are defined as either someone who is designated as confidential under law, so typically that's going to be your state law, or someone who the district designates as confidential for purposes of receiving reports of sex-based misconduct. Now, I very much don't recommend that school districts designate employees for confidential reporting. And that's in large part because children are not adults, obviously. And although in colleges, it's really important to have confidential resources for people to go and talk to because these are adults, in your K-12 environment, I have never seen anything good come from a K-12 employee knowing that someone was sexually assaulted and not reporting it to the supervisors in the school district. Doesn't necessarily mean that you have to do something about it if you're that school district, but it's just having employees be able to keep that information to themselves can create a whole bound of concerns that are well beyond Title IX. There may be, depending on your state law, some employees who are confidential under your state law, but I would be very surprised. So please work very closely with your local council in your state who are very familiar with your, for example, mental health confidentiality laws, to try to determine whether or not employees in a school district who are not actually providing mental health treatment, but rather are providing educational services, whether those individuals are protected by your confidentiality provisions. If they are, or if you decide to designate some individuals as confidential, you are required to train them. You are required to train them that when they receive a report, they have to notify the person who is reporting to them of several things, including how to contact the Title IX coordinator, how to make a report, what their confidentiality means as far as what they will and will not share about what was told to them. And then also that there are things that the Title IX office can provide that the confidential reporter can't provide. And this is a really important one because it's important for people to understand that if I choose not to report something to my school district, that means they can't help me. They can't help me with supportive measures. They can't help me with doing an investigation that could allow discipline. So you are going to be required to train those individuals if you decide to go that route.
I agree with Jackie on confidential employees 100%, in that I would not designate any if they are not designated under state law. The only thing I would add with respect to confidential employees is also, once you've done that research and you've consulted with your attorney and you've figured out whether or not they really are privileged, if the answer to that question is no, their communications are not privileged or confidential under your state law, make sure they know that. In my experience, it's not unusual for guidance counselors to believe, or school counselors to believe, that their communications are more confidential than they are. So I would make sure that they know that they still have a duty to report if that is the case in your school. And then the other thing I would add, I completely agree with Jackie that we should be making sure that we're covering skills and basics in our trainings to make sure that they are given skills that they can apply, whether we're talking about the 2020 rules or the 2024 rules, right? Good investigative skills are good investigative skills. But I would also add that the training has expanded for your Title IX team, in that who is on that team has expanded, or who is required to be, who is considered to be on that team has expanded, I should say. So for example, they now explicitly require training for your designees. So anybody the Title IX coordinator designates to help them with a task. We would have recommended it before, but now it's required that they be trained. And it's also required that anybody who has authority to modify or terminate supportive measures be trained as part of your Title IX team. And so if you, as a school district, allow your campus administrators, who are often charged with implementing these supportive measures, to modify or terminate them, you're going to need to make sure that they are being trained on Title IX and the new rules and what their duties are under those rules. And that brings me to another step in the grievance process that we didn't talk about earlier, but that is that there is a new requirement that you be allowed to basically to challenge supportive measures. So students can say, I would like this supportive measure to go away, or I am challenging the fact that you didn't grant me a supportive measure. So that's one really good reason for Title IX coordinators to think ahead about how they want to handle supportive measures in the first instance, because if it's designated to somebody else to make the first call on them, the Title IX coordinator can then be the person to hear that challenge and make the decision on that. Or maybe the Title IX coordinator wants to make the first call and then think through who is going to be making the second call on those supportive measures. So, and similarly, I know that there are some Title IX crime coordinators who would on the fly decide, oh, I need help from this person in this process, and make the decision based on the specific circumstances, but that designee might not have been trained. And so coordinators are just going to need to think through, and with the rest of their leadership team at their school district, who they might use as designees and who will have authority to modify or terminate supportive measures, and make sure those people receive the training that they need.
Well, and even if you're still under the 2020 rules, I actually interpret the 2020 rules to require training for anyone who's delegated a responsibility by the members of the team already. So I don't see that as just like a best practice or recommendation. So even if you are working under the 2020 rules, if you are delegating responsibilities from someone in one of those roles, please make sure that those individuals are trained at least on the elements, the requirements for that particular delegated responsibility.
Absolutely.
Okay, so this is I'm very excited to shift to this part. It is the T, if you will, of the state lawsuits. We've seen that several states are suing the Biden administration over these changes, or that they conflict with already set state laws. So what's going to happen, and how will this be resolved? We'll start with Jackie.
Yeah, I've obviously been alluding to this a ton. So this is just something that is really hot right now and is just creating a lot of headaches for Title IX coordinators like myself. So there are currently 26 states that are suing the US Department of Education to block the Title IX rules. Most of those lawsuits are really focused on the LGBTQI plus provisions in the regulations, but you wouldn't know that from the court decisions that have been being released in these cases. And so far, we've seen 2 courts that have ruled on temporary injunction requests. And for any of you who don't follow all of the lingo of injunctions in courts, I don't blame you, but a temporary injunction is basically, it's a short stay of a regulation in this case, while the court is able to go through the process of a hearing and a trial on a larger request for a permanent injunction. So what's happened is that in Kentucky and in Louisiana, 2 trial courts at the federal level have enjoined the enforcement of the 2024 Title IX rules, and they've done that in 10 states. So interestingly, for example, the states of Idaho and Montana and Mississippi did not file their lawsuits in their own states. They joined in a lawsuit in Louisiana. And the same thing in Kentucky. I'm probably not going to be able to rattle all of these off, but I know it's West Virginia, Virginia. I believe it's Ohio is in there, Kentucky, Tennessee, and I'm maybe missing one there. But those are the states that are covered by the Kentucky case. They didn't file their own lawsuits in their courts in their state. They joined with Kentucky. So what these decisions mean, well, we don't really know exactly what they mean at this point, because an injunction could be removed at any moment on a moment's notice. So sure, there is a chance that a reviewing court would come in and say, actually, I don't agree with you, trial court, and we're going to throw this out, this injunction. And so now the 2024 rules are going to go into effect on August 1st. Part of the strategy of where these lawsuits was filed was a focus on avoiding that outcome. So Kentucky being in the 6th Circuit, which just issued its own decision that dealt with some guidance that came out years ago at this point on Title IX, and was pretty clear where they're kind of leaning, and that they may have concerns about this rule with respect to LGBTQ issues. Also in Louisiana, that is in the 5th Circuit, which is a circuit that is, I think roundly recognized as one that would maybe be amongst the most supportive of circuit courts in upholding one of these types of injunctions. And then there's another lawsuit that's working its way up right now in Alabama. That's in the 11th Circuit. And the 11th Circuit has already issued a decision on bathrooms where they recognize some limitations to extension of Title IX with respect to transgender student access to bathrooms based on their gender identity. So why am I saying all this? Because yes, there's a chance that these are all going to be overturned. I would say at this point, if you look at the amount of time it's going to take and the circuits that these have been filed in, it's a relatively small chance that these will be overturned by August 1st. It could happen, but it's a small chance. And so what that really means for, I think, for those of us who are in those jurisdictions is that you probably want to be looking at hedging your bets. So I had trainings scheduled. I canceled trainings that were specifically focused just on the new regulations, because if you're in a state where this issue might be in flux, I think hedging your bets and doing a training that is more well-rounded, focuses on the 2020 and 2024 regs, as well as some of those fundamentals I mentioned earlier, is probably going to be a safer bet. If you are in one of the states where a decision has not yet been issued, or if you're in one of the 24 states where you are not suing, you certainly can just continue with your plan to move forward with training on the 2024 regulations only. But I do think we also want to be taking into consideration the fact that there could be changes from the Department of Education, for example. I'm not so sure that I have much faith in the Department of Education at this point, that they are recognizing the horrible situation that school districts in the country have been put in right now, trying to figure out what should we be updating our policies, should we be changing our training, what should we be doing? Maybe they would have some empathy and they might consider staying the implementation of the entire rule. I think that's unlikely, but it certainly could happen. So I'm just really in a mindset right now of hedging bets while this is occurring. One thing I don't think you should slow down on is having a policy ready to put in place. But please, my goodness, if this has not shown how important it is to start thinking about policy differently, nothing will. And I also wrote a blog post on this recently on my Civil Rights Insights, really digging into what is a policy and what is it supposed to do. And a policy is really not supposed to be something that needs to be updated every 4 years when the administration changes. So I won't get into that right now, but I just think maybe take a look at that and think about what your policy looks like in your district and whether there's a way to write one that wouldn't have to be updated. And I'm positive it's possible to write one because I have written one under these rules. So, it's definitely doable. And it's something I think is worth considering in light of all of these changes right now, that so much uncertainty that frankly is not our fault. We did not create this situation where these lawsuits are being filed so close to the implementation deadline. That was a choice that the Department of Education made in choosing to issue these regulations that they knew would be challenged so close to the effective date of the rules.
I just would add that one of the things that has surprised me so far about the litigation is not that there was litigation, and certainly not that the states are winning, because Jackie's absolutely right. They cherry picked the places that they were going to file the lawsuits based on wanting to have courts that they thought would be sympathetic to their arguments. Though all the states have done that. All plaintiffs always do that, or plaintiffs often do that. But what has surprised me is that even though the main focus of the arguments have been the LGBTQI plus protections, and the main focus of the decisions that have come out of the courts have been those protections, they've enjoined the entire rule when they could have chosen to focus only on the parts of the rule that they found most concerning. And so that is one thing that I find interesting, and it'll be interesting to see whether any of these circuit courts, even though I 100% agree with Jackie that they are going to uphold, they're very likely to uphold the injunction in terms of the LGBTQI plus protections. I am curious as to whether any of them will say, you know what, I'm going to make this more limited because you overreached by enjoining the entire rule, even though all of your reasoning is only about this one piece of it. And that is just such a tiny piece of the rule. If you have our guidebook, we have that we produced with AASA, we have a handbook that goes along with it that talks about the rules, and these protections are such a small part of it because it's such a small part of what the rule is. It covers so much more than just the most controversial pieces of it. And then the other thing I would add is, even if you're in a state that does not have a lawsuit, still follow Jackie's advice to hedge your bets, because one of these courts, and especially there is a pending lawsuit in Texas and a court that has issued nationwide injunctions before against Obama, against Biden, and it is not beyond the realm of possibility that they decide, you know what, I'm going to make my injunction nationwide and not just focused on Texas or any states that join it. So that is something to keep in mind as well. And again, I would just emphasize what Jackie said about do what you can. You can prepare for implementation without implementing, including having your policy ready to go. And yes, put as much as you can in procedure, and you really can put almost all of it in procedure, as Jackie noted, because while it requires things be in writing, it doesn't say it has to be in your policy. So keep that in mind as you write your policy, and try to put as much of it as possible in your procedure so that you can shift on a dime whenever we know where we're shifting to and what direction we're running.
Yeah, and if you get your policies from a state policy service, from an association of school boards, think about communicating your wishes to your state school boards association. I was so thrilled to see, for example, that in Virginia, those of you who are in Virginia, you're lucky enough to already be in a state where the state school boards association takes this interpretation of what policy should look like. And so for those of you who are there, you're going to be able to very easily update your policy to address whatever you need to, and to be ready no matter what happens this fall with these regs. But in a lot of other states, that's not the option that's being given to you. And so making clear that you'd like to have that as an option, I think will help a lot with the logistics that you're going to face if you get your state school board's policy and it's not what you want it to look like, and then you have to essentially work with legal counsel to revise that. That's not ideal. So think about if that's something you're looking for, communicating those wishes.
And I would also add, this is such a hard topic to keep up with. I know that our blog has regular updates on the litigation as it's going. We're trying to get posts out very quickly after there are new changes and new court orders. And we also are hosting a webinar next Wednesday, the 26th, that will be discussing the litigation and the status of it and giving updates, because as fast as things are turning, Jackie noted in one of her blog posts recently that how quickly it had changed between her writing it and posting it, right? And so things are changing very quickly. So get your information wherever you can as you have time to, and take advantage of these resources, because we know that you don't have time to run your school districts and closely follow litigation. So take advantage of the resources from those of us that are.
This has been so important and substantive, and I just really appreciate both of you coming on to share these resources. We're going to put everything in the show notes, including all of the guides that we've put together, all these opportunities, a link to the webinar. We'll make sure that our members have that. So thank you so much, both of you, for coming.
Thank you. Thanks for having us.
Thanks. It's been fun.
And that's a wrap on this episode of AASA's PEP Talk podcast. We invite you to share it by using the hashtag PEP Talk on Twitter. You can access past episodes in the PEP Talk library by visiting aasapeptalk.podbean.com. And once again, thank you for joining us.